This is Jon Cohen. I'm a partner at nextlaw.ca, and today I'm talking about the new stunt driving laws in Ontario, and this is lesson 9, police interaction. And this video, it directly addresses the new stunt driving laws in Ontario, which is known as the MUMS Act, which is short for Moving Ontarians More Safely Act. We'll focus more on what you can do before you get to court rather than the court process itself. So my firm, nextlaw.ca, we defend over 500 clients each year that have been charged with stunt driving in Ontario, which means that we field much more than that in phone calls. So from all of those calls, I've compiled some of the questions and some of the confusion that arises at the roadside when you are first being charged with stunt driving in Ontario. So first, let's understand the basics of the law and how the law sees your stunt driving charge. Put simply, the province only needs to prove that you were above the speed limit of 40 kilometers on a road that's less than 80 kilometers per hour posted speed limit, or a speed limit of 50 kilometers per hour or more on a road of 80 kilometers per hour or more posted speed limit. And it's that simple, period. Everything other than that is generally secondary to the burden of proof. So a common concern people often get when you're pulled over for stunt driving was, how does the way that I interacted with the officer affect my case? It actually can have a big impact on your case, and the way in which you interact with the officer is recorded in the officer's notes at the roadside, and then it is later submitted to the courts in the form of something called disclosure or evidence. And this evidence has all the information about your roadside charge. So, for example, 1, the radar reading, 2, the radar calibration, 3, the officer interaction, and 4, all the other details of the charge. You know, saying something like, I didn't believe the officer caught me at the rate of speed in which I was charged, something was wrong with it. Well, arguing with the officer at the roadside has a zero benefit. Once the officer determines that you were stunt driving, they have the authority to charge you. They have the authority to impound your car, and they have the authority to suspend your license. Arguing does not change this. Also, the officer generally does not even have to show you the radar or speed reading. They simply issue the ticket, and then they will have to submit all of that information later to the courts in the form of disclosure. So arguing doesn't make the charge go away. In fact, it makes the charge worse. The prosecutor, who will later see your disclosure and the officer's notes at court, is the person that will be dealing with your case specifically. So if they see that you had a bad interaction with the police, it may make your case harder to settle or reach some sort of agreement. Remember, the prosecutor has a lot of power, and once they have disclosure, they assess your case based on a number of factors, and one of those factors includes this interaction with the police. So here's some tips for interaction with the officer at the roadside that will help. As frustrating as this charge may be, and it is quite devastating in the moment because you've got that immediate 30-day license suspension, that 14-day car impound, there are few rules to follow with the police that may benefit or at least not hurt your case once you get to court. So one of those being, do not get angry with the officer. Also, follow the directions of the officer. Ask any questions in a very calm tone, and do not question the motives or the results of the officer or the radar. Save that for a later date. So what are my next steps after my 30-day suspension of 14-day car impound? It's a good question. You've now been charged with stunt driving, but it does not mean that you will be convicted of stunt driving. The charge is just the beginning of the legal process. And yes, again, it is a devastating start because you now have that 14-day car impound and that 30-day license suspension at the roadside before you even get to your court date. So now is time to get some legal advice and proceed very carefully, because while stunt driving may seem on the surface like a traffic charge that many people may not take seriously, think more about how you would function if your license was suspended and you couldn't drive for a minimum of 1 year, which is one of the penalties for stunt driving. You run the real risk of losing your job, not being able to get to job interviews, not being able to take care of your family, not being able to use a car for emergencies, and 1,000 other reasons associated with driving a car. And that's how serious the charge can be if it's not dealt with properly. So this video is an attempt to get you to reach out and get free legal advice, because a proper law firm that specializes in stunt driving may have a legal strategy and a legal course of action that can prevent this license suspension. And best of all, this call is free. So you can scroll down below, you can book a free meeting with Dan Joffe or myself, Jon Cohen, and there is no obligation, but the call could change everything.